Jim Hickman is with us from Charlotte, North Carolina tonight. He's a partner at the law firm of Hickman and Perrin and is an expert in wealth transfer, estate planning, trusts, tax, and probate law issues. Jim, with the COVID-19 crisis, so many of us are scared and thinking about a topic that we maybe weren't quite ready to think about, and that's our last will and testament. I've heard so many things related to this, and what happens if you die without a will, but I'm not sure what's true and what's not. Can you walk me through this?
Yes, I'd be happy to, Larry. What happens when you die without a will is referred to as intestacy, or you may die intestate, no will. And if that's the case, you die with no will, then in North Carolina, at least, the state of North Carolina's General Assembly has decided where your property is going to go. It will pass to certain individuals based on your relationship to them at the time of your death in certain percentages. And frankly, that may not be the distributive scheme that you would like to see happen with your property at death.
So what does that look like? Can you give me some examples?
For example, if you're a husband and wife and you have no wills, but you have children, except for those assets that are passing by right of survivorship, everything else that you may own is going to at least fractionally go to your children. You may have wanted it all to go to your spouse. What if you're a partner in a dental or law practice and you die with no will, and lawyers do all the time, then your property is going to go, again, to folks that you may not want it to go to. For example, here, if you own a business, do you want a fraction of your medical practice or your interest in it to be passed to your 6-year-old child? And most folks, when they're looking at it from that perspective, will say, well, no. And it makes sense at that point to start thinking about how are you going to pass this wealth from yourself to your spouse or from both spouses down to further generations.
So, Jim, what happens if you die without a will in place and your surviving spouse wants to sell the house?
Well, if you die and your surviving spouse inherits the house from you, then she can or he can, of course, do anything they want to with it. Now, looking at this from a different perspective, what if you were not dead? What if both spouses were living, but one was in a nursing home and didn't understand what was going on with Alzheimer's or dementia or some other incapacitating illness? In that case, without certain documents in place, the surviving spouse, or the spouse in this case, would not be able to sell that property. You have to go to court and get an order and have a guardian of this spouse appointed by the court in order just to sell the property.
Now, is there anything you can do to not have that happen?
Absolutely. A simple power of attorney, giving your spouse the right to sell property on your behalf.
So let's talk about actually getting a will. What's the process of getting a will done? Maybe I already have a will, and maybe it needs to be changed. There's been some things that have changed in my life. Maybe I've gotten remarried. But what kind of preparation do I need to do, and what's that process look like?
Well, usually you can do several things, anywhere from going online and downloading something from a website to actually engaging a lawyer. And many lawyers will do estate plans and draft wills, but my clients, the ones that I work with, actually want something other than some form that comes out of a book. We actually are not as concerned about the drafting the instruments, although we're very careful. We go through this process with our clients to ask them specifically, where's your property? How is it owned? Who do you want it to go to? How do you want it to go to them? Do you need a trust? Do you have minor kids? Do you want to set up a trust for the kids in case both parents perish, perhaps in a common disaster? So those are all questions that we go through our clients with. We give them homework to do before they even have their first consultation with us, to save them time and money and to give us a fairly quick perspective on their planning situation.
So, Jim, what are some of the things that people should consider when choosing an executor or a trustee?
Another great question. If you're 50 years old, for example, and you want to name an executor, your 55-year-old brother may not be the best choice because he's older than you, obviously. He could have health problems at the time of your passing, if he's even alive himself. Do you want to name your surviving spouse? Well, that's usually the case. Most folks will name their surviving spouses. And more frequently now, although it's been very common in the past, is to name a corporate fiduciary to act either as a co-trustee with your spouse or another family member, or to serve as a sole trustee, meaning they assume all the responsibility for managing the assets, preparing tax returns, making the distributions to the beneficiaries, keeping track of income and principal, and making sure that income is paid out to the surviving spouse if that's what the trust requires.